Today's segment is when a person dies with a will. Today with me in the background, I have Jessica Diab, who is the senior partner of McLaren's Lawyers, who will be asking me a few questions which we get asked frequently by some of our clients on the grant of probate process.
Thanks, Diane. Yes, what is grant of probate?
So a grant of probate is a legal document that authorises an executor to manage the deceased's estate in accordance with the deceased's last will and testament. So when a person dies with a will, a grant of probate often needs to be lodged with the New South Wales Supreme Court. There is no statutory requirement to obtain probate, as it varies on a case-to-case basis. So some of the examples can depend on 1, the size of the estate, 2, the type of assets which are involved, and 3, the value of the assets. So some asset holders will often release smaller amounts without the need to apply for probate to be obtained.
Thanks, Diane. And who can apply for a grant of probate? And what happens if an executor does not want to act?
So the executors of a will can apply for a grant of probate. If an executor is unwilling to take on the role as executor, they can renounce probate. If the renouncing executor is one of several instituted executors, then the remaining instituted executors can apply. If the renouncing executor is the only surviving instituted executor, then the substituted executor may be able to apply if the will provides for a substituted executor. So a lot of my clients say, Diane, is it wise we appoint a substituted executor? I strongly recommend to all my clients when making a will to appoint a substituted executor in the event the instituted executor is unwilling or unable to act.
Thanks, Diane. And how long does probate take to be granted from the courts?
Sure, so provided there are no complications, the Supreme Court usually takes between 4 to 5 weeks for probate to be granted after the application has been submitted to them. So in terms of retrieving assets and administering the estate once probate is granted, will depend on how complex the estate is. So it does vary on a case-to-case basis.
What is the process at McLaren's Lawyers when a person needs to apply for a grant of probate?
Sure, so in a nutshell, first of all, an appointment would need to be arranged by the executors of the will. Upon their appointment, they must bring the deceased's death certificate and any other important documents, such as the will, bank account statements of the deceased, any dividend statements if the deceased owned any shares, or any other important document which would assist us in working out what the deceased owned as at the date of death. During the appointment, we will carry out the reading of the will and obtain instructions as to what the deceased owned at the date of death, and we will also require an estimate of the value of each asset. So if probate needs to be granted, then we would need to publish a probate notice on the New South Wales online court registry. We must wait at least 14 days from the date of publication to file a summons and probate application. So during this time, we will prepare the relevant documents which will need to be submitted to the courts, such as the summons, the affidavit of executor, and the inventory. Thereafter, the executor or executors would need to arrange another appointment to sign the probate documents and other relevant documents to release the funds in the estate. When probate application has been executed, we will send the application to the New South Wales Supreme Court. So then once probate is granted, we will then correspond with third parties to ascertain certain funds. For example, if the deceased had an accommodation bond at the nursing home, we will correspond with them. Correspond with banks, share brokers if the deceased held any shares. Now, if the deceased owned a property, we will need to discuss in undertaking a transmission application in order to remove the deceased's name off the certificate of title. So once we recover all the funds and we are ready to distribute the estate, We usually send our clients a distribution letter, which sets out how much everyone is entitled to receive in accordance with the last will and testament. Prior to distributing the estate, the executors will need to confirm that the beneficiaries are not bankrupt. Bankruptcy of a beneficiary would require the benefit to be paid to the relevant trustee in bankruptcy. So as you can see, the time frame of obtaining probate and distributing the assets can vary on a case-to-case basis, depending on the complexity of an estate. So if you are the executor and need advice about obtaining a grant of probate, feel free to call one of our estate solicitors here at McLaren's Lawyers. Thank you.
Thanks, Dion.
Thanks, Jessica.